So first today we will be discussing about the dying declaration and few other procedures. So dying declaration already it was discussed. So it is under section 32 of the Indian Evidence Act, when the statement was made by a person as to cause of his or her death and as to any of the circumstances that led to his death condition. So somebody who is dying, so what was the condition which led to his this condition, this situation? So that is called the dying declaration. And procedure for dying declaration, I'll be going a bit first because already it is discussed. The doctor is to certify that the role of the doctor. What is the role of the doctor? They have to certify that the person is compos mentis. So mentally he is sound to give the declaration. Okay, so that is the role of the doctor in the dying declaration process. But there are some buts I will discuss later. Oath is not administered because it is believed that the dying person tells only the truth. So the oath is not required. So whatever he is saying, it is presumed that he is telling the truth. And no leading question is asked. Just it is the narration in the language of the person and it is to be recorded. Right? So already these things are discussed. Now magistrate should be called to record the declaration. So usually the magistrate is to be called for recording the declaration, but it is when the death is imminent, the person is dying, you have given the information to the police to call the magistrate, but the magistrate is not arriving. In such type of cases, I am talking about the hospital scenario. Anyone, including the doctor or the police officer, without losing any time, they can record the statement of the person. Anyone can record the statement of the person. And if this is the situation, I am discussing about the situation in a hospital setup, but if the person is not in the hospital, then anyone can record the statement with signature of two witnesses. So in those type of cases also, it will be taken as a dying declaration. The court will take the cognizance. The statement of the declarant should be recorded as he narrated, already discussed. While recording the statement, if the declarant becomes unconscious or the person recording it, must be, he has to record that what if the person became unconscious and so, or the person has deteriorated, the condition of the person declarant has deteriorated, so he has to stop it and he has to just make that declaration that this thing has happened and we are stopping it. Signature of the thumb impression of the declarant is taken along with the signature and thumb impression of the witness. These witnesses, these are very important. Okay, these witnesses must be the person who can be traced later on, who can give evidence, who can be summoned to give the evidence. Then fitness of the declarant to make the statement is certified at the conclusion of the statement if it is recorded in the hospital setup. Then the declaration is sent to the magistrate in a sealed cover. Already up to this much we have discussed. And if the declarant survives, so still the declaration will be having some documentary value, but evidentiary value, but it will be subjected to cross-examination, oral evidence to authenticate his statement. So the person, if he survives after giving the declaration, then he will be called to the court to testify that yes, this is the declaration he has given. There is no prescribed format for recording the dying declaration in India. There is no prescribed format, and dying declaration could be oral or written. Any adequate method of communication, whether it is word, sign or otherwise, would suffice the provide that the indication is positive and definite. So whatever language the person is using, whatever means of expression the person is using had to be taken. Then any member of the public can record the statement. As I said, whatever we discussed, that was in the setup in a hospital setup. But if the person is not in the hospital, any person to whom the person has declared regarding the condition, the situation leading to this condition, so can record the statement and it will be treated as a dying declaration. Moreover, the requirement of the certificate, and many times it is so in those type of situations, it is not possible for the doctor to certify that the person was having compos mentis because he have not examined the case. That is why this is a case in the Supreme Court, Honorable Supreme Court of India. So, State of Madhya Pradesh was the appellant versus the Dal Singh and others respondent. So, in this case, it was clearly mentioned that in all the situations, the statement, the declaration by the doctor regarding the mental status of the person, whether he can give the statement or not, it is not mandatory. If it is in the hospital, then definitely the doctor can declare it. He is examining the person. Otherwise, it may not be there. The next, another term is the dying deposition. The magistrate records the evidence after administering the oath in presence of the accused and his lawyer. There is no provision of dying deposition in Indian Evidence Act, so it is not followed in India. So here the magistrate records the evidence after administering in presence of the lawyers. So it is something like the court is shifting its position to the positioning itself near the patient who is dying. So the whole court will be going there. There will be the lawyers of the opposite party will be there. It will be a court by the side of the bed. Okay, so difference between the dying declaration and deposition, it is asked in the viva, comes as short note. So Fisher's first statement. In dying declaration recorded by anyone. Okay, so he may be a doctor, he may be a village headman, police, or any other member of the public. But dying deposition, it is always recorded by the magistrate, that is judicial magistrate. Magistrate having the judicial power only can record the dying deposition. Then oath is not required in the dying declaration, but it is a must in the dying deposition. Because it is just trial by the side of the patient. Accused or his counsel or the lawyer, it is not present in the dying declaration, but in the dying deposition, they are always present and they have the right to ask question in appropriate time to the person, the declarant. Then cross-examination, there is no question of any cross-examination because it is not a court, but in dying deposition, cross-examination is done. What is cross-examination? We will be discussing just afterward. Then legal value, comparatively less. Because dying declaration, it is just declarant. So he has declared it and the person is not available for cross-examination. So evidential value is comparatively less in comparison to the dying deposition. Because it is recorded by the magistrate in presence of the lawyers under oath. So it is something like the statement given in a court. Admissibility if the declarant survives. Has corroborative value. So the person, if he survives, as I said, he will be called to the court for oral evidence and for cross-examination. And in dying deposition, they will be fully admitted because it is a statement given in the court. In dying declaration, it is merely recording of the statement, but in dying deposition, it is a complete court procedure. And type of evidence, here it is documented evidence and here it is oral evidence under oath. Role of the doctor in dying declaration, assess the compos mentis and record the statement in absence of the magistrate but in presence of the witnesses. But here, assess the compos mentis and the statement always recorded by the magistrate. The doctor has to certify that the person is capable of giving the statement. Then status in India, it is dying declaration is followed here, but it is not followed, dying deposition is not followed in India. Now let us discuss something about the witness. A witness is a person who gives sworn testimony or evidence in a court of law as regard of the facts or inferences that can be drawn from this. Okay, so he is the person who will go to the court and give the evidence. Yes, I have this knowledge about this particular case. Okay, he may be a common witness who have seen or who have heard about the incidents, he have some knowledge about the incidents, or he may be an expert witness, suppose the medical practitioner. He have done the examine some sexual assault survivor. Now, whatever he have given, so that will be on the basis of his examination findings, so that will be considered as evidence. So, in that case also, when he will be called to the court, he have to go there as a witness. Now, types, common or ordinary witness or lay witness, so they are the persons who have seen something, or just laymen. They have seen something, or they have some knowledge about that incident, particular incident. So they are called to give evidence in the court of law. Then expert or skilled witness. So they are the expert. Okay. So as I said, the doctors, they will be expert witness if they give the evidence as per their examination finding, as per their expertise in that particular field. When they are giving the evidence in the court of law, so they will be treated as expert witness. But it is not always the fact that doctors will be always the expert witness. Suppose you have recorded the dying declaration, then the person has died, and you will be called to the court. You may be called to the court to give the evidence to certify that yes, I have recorded this statement, and the person concerned has given this statement. So that then it will be a common witness. You are not doing any expert job there, but you have examined the person, you have done the autopsy, you have done some examination as per your skills. So in those type of cases, you will be treated as an expert or skilled witness. Next, another type, that is called the hostile witness. What is hostile witness? We will be discussing later on. Just remember. Now, difference between the common witness and the expert witness. First definition gives evidence about the facts observed or perceived by him under section 118 of Indian Evidence Act. And expert witness, persons specially skilled, say in foreign law, science or art, etc., whatever it is. So that is under section 45 of Indian Evidence Act. So these are the persons, they are having some expertise in the field, some foreign law or some legal matters, or for science, medical science, engineering, or whatever it is, or some arts, say in some art form. So they will be called according to their expertise in relation to that particular case, and they will give their evidence as per their skills. Then volunteering of the statement, it is not allowed, can volunteer. What is volunteering of the statement? Suppose in a case you are giving the witness, you are the witness, and you are telling something to the court. Okay, so there you are finding that actual fact is not coming out because the questions are something different. You are not able to ventilate what you want to tell to the court regarding the actual fact of the case. So an expert witness, he have the right to volunteer the statement, and if the expert witness volunteers the statement, and the court have to, the judicial officer have to record the statement word by word, whatever he says. Okay, so that is the privileges enjoyed by any expert witness. Okay, so that is a privilege for the expert witness only. The common witness, they cannot volunteer their statement. Whatever is asked, they have to just give the answer regarding that. But in an expert witness, he can volunteer the statement. Then drawing inference or from the observation, it is not allowed. But here expert witness, he can draw the conclusion. Suppose the findings are there. Suppose you have done one autopsy. Okay, it happened many times with us. So I have done the autopsy, and I have preserved some viscera for chemical analysis. It is sent to the forensic science laboratory. I have prepared the provisional autopsy report without the cause of death, because cause of death will be pending till receipt of the report of the chemical analyzer. Now I have gone to the court, and in the court I am provided with my autopsy report and report of the chemical analysis. So on the basis of this finding, I have not given the final opinion because I have not, because of some lapse on somebody, I have not received the chemical analysis report. Okay, the police has received it and sent to the court. Now in the court, if both the reports are given to me, I have the privilege to draw the conclusion on the basis of the finding. Okay, so that is the role of the privilege of an expert witness. They can draw the inference or the conclusion on the basis of the findings. It is not that the expert witness, they can draw the conclusion on the basis of his or her finding only. Many times the findings of other doctors, many times the autopsy is done in the periphery, not by forensic medicine persons. Okay, or some other examinations or forensic examination, it is done by some non-forensic persons. So those things are also sent to us, and on the basis of their finding, yes, we can give the conclusion, yes, this is the opinion regarding this case. So that opinion can be drawn only by the expert witness, not by others. Similarly, in other fields also, they can, in other fields like of medicine or any other expertise, so they can draw the conclusion. Then expressing opinion observed by, made by the others, as I say. So it is, if the observation is there, you can draw the conclusion. Then responsibility, it is less, it is highly responsible because you are expert in the field. If you do some mistake, you'll be even liable to lose your degree. Then punishment or for giving false evidence, it is less punished, but here severely punished because they are expert. They are supposed to know the facts. Okay, if they deliberately give some false evidence, definitely their severity of the punishment will be more. Then conduct money. What is conduct money? I will tell you. So cannot claim, the common witness, they cannot claim the conduct money, but the expert witness, they can claim in civil cases only. In the civil cases, if the conduct money is the money paid to the expert witnesses to meet up the expenses for travel and all. Okay, suppose somebody is called to give evidence in Delhi, so whatever the up-down fare for the admissible, whatever is admissible, so they have to be, or the lodging, fooding, all these things have to be compensated by the court. Okay, so the conduct money, but that will be in the civil cases only. In criminal cases, the person who is going in his official capacity, he have to claim the expenses from his employer. Okay, so in civil cases they can claim the conduct money, but not in the criminal cases. Examples, any person. So common witness can be any person, but expert witness, handwriting expert, fingerprint expert, doctors, chemical examiners. So these are the common expert witnesses. Okay, if they are giving evidence in lieu of their expertise, then only they will be expert witnesses. Now let us discuss about something regarding summons. It is asked in the viva, what is the definition of summons? It is a document compelling the attendance of a witness in a court of law under penalty on a particular date, time and place for a purpose of giving evidence. Okay, so it is a document signed by the presiding officer of the court. This document is not just something in a white paper. It has its own format. It will be signed by the presiding officer of the court, and that will compel the attendance of the witness in the court of law under penalty, means he have to take the oath on a particular date. So the one particular date, time, place, everything will be mentioned there, and for giving the evidence. Why he is called? To giving the evidence. So that is the summons. Other names are sapniya. So these are there. Now, so summons, it is section 61 to 69 deals with of CRPC deals with the summons. How to issue the summons, if it is a government servant, how to issue the summons, so all these things. So it is by the court, it is issued by the court in duplicate and signed by the presiding officer of the court, bears the seal of the court. So as per the under section 61, the how to issue the summon, all the procedure is described here. Okay, so everything is described here under section 61 of the CRPC. Then it is served to the witness by the police officer or by the any officer of the court or any other public servant. So it will be served to that person. It is the duty of the court to make sure that the summon is served. The witness retains the copy. One copy is retained and the other copy is returned, duly signed by him on the back in acknowledgement of his receipt. Okay, this is the procedure under section 62 of the CRPC. You have to retain one copy and the other copy is returned back. The summon must be obeyed and failure may lead to liability to pay the damage in civil cases and if it is a criminal case, then there may be fine, even the jail may be there. So the punishment may be there for not attending the court. The summon have to be obeyed. Now, if the court finds that the witness are absent deliberately without any justification, so there may be sentence for imprisonment. As I said, there will be punishment for non-attendance of the summons. Then sometimes the witness may also require to bring with him any document, book or something. The court will inform you. So suppose they need some document from you. In the summons itself, it will be mentioned that what are the things that you have to carry along with you. So a witness may be excused from attending the court if he has a valid or urgent reason. So I had some summons in some different courts, but I could not attend it because I had to go to some places for taking exams. So I have given the intimation to the court, so it is not a issue. But if I don't attend those summons without any intimation to the court, then it will be taken cognizance and the person may be punished for that. In cases of summons from two courts on the same day, same time, then preference should be given which court should be attended first. So first, the criminal courts have the priority over the civil courts. Okay, criminal courts, for any procedure in the criminal courts, it have to be first. Preference is to be given to the criminal courts. Then higher court has the priority over the lower court. Suppose you are getting a summons on the same day, for the same day, from the chief judicial magistrate, one from the session judge. So definitely you have to go to the session judge, but you have to give intimation to the other court, the lower court, that you have two summons, you are going to this court, so you are unable to attend the other court. You have to give that information. In case summons from two courts of the same day, same time, of the same type of the court, suppose two summons from the different session judge, then you should attend the court which was received first, from which you have received the summons first, and inform the other court. But always you have to give the intimation regarding your inability to attend the court in advance. In no case the witness should avoid attending the court without information to the court with justifiable cause. If you do not have any justifiable cause, then it will be taken as contempt of court, and in those type of cases, even non-bailable warrant may be issued against you. You may be arrested for that, for disobeying the court order. Now, conduct money, it is the fee offered or paid to a witness in civil cases at the time of serving the summons to meet the expenses towards the attending the court. So, please remember, it is in the civil cases, not in the criminal cases. So, the conduct money is just to meet the expenses towards attending the court. The fee is not paid, or if the amount is not less. If the amount is less, it is not covering the expenses, you have to bring it to the notice of the judge before giving the evidence. The judge will fix the amount to be paid. you are going to suppose to Guwahati, Upton fare is this much, and the court is and the conduct money given is very less. Then you have to inform the court, I cannot, it won't meet my expenses, so please make it more up to this much. The court will take the cognizance of it and fix the amount accordingly. In criminal cases, no fee is paid. It is because in criminal cases it is the state versus somebody, so it will be called by the state, may be called by the state. So in those type of cases, you cannot demand the conduct money. However, you can reimburse your expenses from your office. So you have to attend the court in the interest of the state in securing the justice, or will be charged. If you do not attend, then you will be charged for contempt of the court. Conveyance charge or daily allowance can be claimed, as I said, as per the government rule. You are a government servant, so the person can get it from the government as per the rules, or even the private setup also, they have to give you the expenses. Now this is one important thing, it is asked in the Viva, comes as part of the long question also, short note also. Steps of examination is like witness. So first step is the already described, that is the summons. You will be receiving the summons. So after receiving the summons, you have to go to the court, attend the court at the time slot allotted to you. You have to attend the court. Then after attending going to the court, you have to deposit the summons to the party who called you. Okay, so you will give the summons to him. Say you will be called by the state. So in the state, for the state, there will be the some lawyer for the state will be there. Okay, prosecution lawyer. So you have to give your summons to him that I have come here, I have this, or you can directly go to the court and give the summons to the court attendant. Then you will be called to give the witness. So before starting the process of in the court, first you have to take the oath under section 51 of IPC. You have to take the oath. Then the oath is taken. If you are a believer of God, then you have to tell that I'll tell the truth, only truth, nothing but the truth. So you have to take the oath in the name of God, or you have to solemnly affirm that I'll tell the truth, only truth, nothing but the truth. So like that, a oath is there. So you have to take the oath. Then comes the examination in chief. So examination by the lawyer of the same side. So if you are called by the state party, so then you have to the lawyer for the state, he will be prosecution lawyer, he will be just ask the question, examination. But here he will be asking you the name, address and all these things, what you are doing, where you are posted, all these things will be there, and just now you tell what is your knowledge about this case. Okay, so that is what he can do. He cannot ask you that do you have, suppose you are giving the evidence that you have seen somebody murdering somebody. Okay, he cannot ask you that Mr. A, have you seen Mr. A murdering this Mr. B? He cannot ask like that. He can ask you what do you know about this incident? Where you were there, have you seen anything, regarding this incident? Whatever you are having, knowledge you are having, you just narrate the incident. Okay. Then comes the cross-examination. That is the examination by the lawyer of the opposite side. So the defense lawyer, defense counsel, always he will try to find out some fault in your statement or in your report, whatever you have given. So here he can ask you something, have you seen B murdering A, or something like that. These are called the leading questions, where the answer will be just yes or no. Have you seen this? Yes or no? Okay, so this leading question is allowed in the cross examination only. There is exception, I will discuss later. Then there will be re-examination. Suppose the prosecution lawyer find that this examination in chief, he have narrated something, then in the cross examination something else is also coming up, then this prosecution lawyer, he can go for the re-examination. So it may be subjected to the re-examination by the prosecution side again. And there is another stage that is called the court question. That means the question by the presiding officer, he can ask question at any time, any stage of this giving evidence. Okay, so these are the different steps of examination of a witness in the court of law. It is always asking the viva, please remember. So examination chief, examination by the lawyer of the same side, cross examination, examination by the lawyer of the opposite side, then re-examination by the again lawyer of the same side if he find that something else is coming up, then question by the court. Okay, these are the steps. And please remember, leading question is allowed only during the cross examination. The exception is there, we will discuss later. So these things are described in under section 137 of the Indian Evidence Act. So this is the oath. So the word oath includes the solemn affirmation to substitute by the law. So whatever I said, leave it. So now comes the leading question. It is as per the Indian Evidence Act, section 141, leading question. Any question suggesting the answer which the person putting it wishes to or expect to receive is called a leading question. So if I am asking you, are you attending the class now? What will be the answer? Either yes or no. Right? Have you understood whatever I say? Either yes or no. Okay? But if I ask you, okay, what was taught in the class today? So that will be something like the examination in chief. So you have the liberty to narrate everything. But if I ask you, did I tell you something about the leading question? The answer will be only yes or no. Okay, so that is called the leading question, where the answer will be just, probable answer is just yes or no. Okay, so I am not allowing you, I am just curtailing your liberty to explain the things. Just I want this thing. Here, there is the problem. I am just giving one example. I have to give the example here. So it is my personal experience. So I was in the court. It was a case of homicidal strangulation. So I have, after the examination in chief, I was asked by the defense counsel, now cross-examination. In the cross-examination, I was asked whether the rigor mortis is present or absent. I said, yes, it is present. Then he said, rigor mortis is present in hanging. Then what will be the answer? Either it is yes or no. But rigor mortis, it is a post-mortem phenomenon. It has nothing to do with whether it is homicidal strangulation or suicidal hanging. Okay, so he asked me whether rigor mortis is present in hanging or not. Then I told the court that I cannot answer this question in yes or no, because it is a rigor mortis. I explained the court. Then the court said, okay, you just tell yes or no, whatever you say. You just tell it, then I will put the question. The court was favoring me, so he put the question. Then I said, yes, rigor mortis is present in cases of hanging. Then before any question by the defense counsel, the court asked me, now you explain what you want to say. The court was in my favor, so he gave this liberty. But in this situation, in this type of situation, if you find that the court is not giving you that liberty, you can go for the volunteering of the statement. So in that case, if you find situation is like that, you are not able to ventilate the thing, whatever you are supposed to do, then you have to go for your volunteering of the statement. So then you can explain everything. The rigor mortis, it is a postmortem phenomena, irrespective of whether it is sorry, suicidal hanging or homicidal strangulation, it will be present in all cases after death. Okay, so that is what is the that is what called the disadvantages of the leading question, and in these type of situation you can go for the volunteer of the statement, but it is a privilege, again I am telling, it is a privilege by the expert witness only, not the common witnesses. So as I said, the probable answer will be either yes or no. So leading question must not, if objected by the adverse party, so it is not allowed in the examination in chief. Only in the cross examination the leading question is allowed. Okay, just you remember that much, that is enough for you. Now comes the perjury. So okay, before that let me tell you one thing. This, as I said, in cross leading question is only allowed in the cross examination, but there is one exception, that is where the leading question may be allowed in the examination in chief. So the exception is that if the person is the witness is declared as a hostile witness. What is hostile witness? I will tell you later. So if this party who called you, so you are appearing for the state, and the state finds that, the prosecution lawyer finds that you are giving some false statement, you are going out of away from your actual statement, then a statement given by the person previously, then he can appeal to the court to declare the person as a hostile witness. Then to extract the actual fact, the leading question may be allowed, leading question will be allowed in the examination in chief also. That is the exception. If the witness is declared hostile witness, then only the leading question will be allowed in the examination chief. Otherwise, leading question is allowed only in the cross-examination process. Now, perjury, a witness who, after taking the oath or making a solemn affirmation, willfully makes a false statement. So, perjury in simpler form, it is the false statement by a witness under oath. Okay? So, willful false statement under oath, if somebody is giving false statement, that is known as perjury. And under section 193 IPC, the imprisonment may go up to 7 years. Okay, different steps are there. It may be 3 years, it may be, but the maximum the punishment is up to 7 years. Now comes the hostile witness. Who is a hostile witness? Any person who willfully or with motive conceals part of the truth or tells lie or gives completely false evidence in the court. Okay, so if you just see these two things, both are similar, right? If you do not understand, just ask me again afterward. This perjury and the hostile witness. Actually, the hostile witness, it is a part of the perjury. And if you see, if you go to the later part, so in that you'll be understanding that hostile witness, the term is just different, but the punishment will be as per the perjury. Okay. So here some contradict the statement of the witness made in the previous depositions. Okay, suppose he have given some statement to the police, okay, and on the basis of the police, the police has made the case. Then he has given some statement to the magistrate. Now he is giving a different statement, just the opposite to that. In that case, the person may be termed declared as a hostile witness. So he have given some statement. Now he is going away from that statement. He is giving, the best example is the best bakery case. If you just see the best bakery in the net, what are the statement? I forgot the name of the lady. So there she changed the statement twice. So that is called the hostile witness. Then that witness may be declared as hostile witness, and this hostile witness will be declared on the plea by the prosecution side. It will be declared by the court. The court only can declare the hostile witness, and the court will declare a witness as hostile witness on the basis of the plea by that particular counsel of the prosecution counsel, okay, prosecution lawyer. So similarly, suppose somebody has given a statement in the lower court and now in the higher court he is giving a different statement, then also he may be, so in the lower court he has given the statement under oath. Now he is going back from his statement in the higher court when he is called to the higher court, may be called sometimes. Then he will be hostile witness. In that case, his maximum punishment go up to 7 years. So in those type of cases, if the person is declared as a witness, is declared as a hostile witness, then the leading question will be allowed in the examination in chief also. Okay, please remember, hostile witness is declared by the judicial officer court only, the presiding officer of the court, on the plea of the prosecution side who called the witness. Okay, so regarding the punishment, as I said, both are basically similar, this perjury and the hostile witness. There is no separate punishment provision for punishment for hostile witness. It will be under section this perjury only. So if the witness makes the statement under oath, it is found to be false, it becomes a perjury. Okay, so he has given some statement under oath and now it is found that it is false. So if the witness makes the statement not under oath, then found to be false, say a statement given to some police or some other procedure where the oath was not taken. Now he is deviating from that statement. The case is he is called on the basis of his earlier statement, but now he is deviating away from his earlier statement. Then he will be declared hostile. Okay. If proved hostile, he will be punished under section IPC section 193 for perjury with imprisonment, which may be 7 years for false statement under oath. Suppose he has given some statement in the previous judicial proceeding under oath. Now he is giving a false statement under oath again. So suppose this statement is false, then he will be liable for punishment under, if the statement given is false, the statement given under oath is false, then it will be 7 years. And if the other statement was false, now he is telling the truth, but the statement given earlier, it was a false statement, it was not under oath, then the punishment will be 3 years. Okay, so I think this clears. Please don't confuse this. Most of the time you confuse this part, perjury and hostile witness. Please remember, there is no separate act for separate section for hostile witness. It is the person will be punished under section 193 of the Perjury Act. So IPC section 193 only the declaration of the hostile witness, that is the process. It is a process only, but the punishment will be under section this perjury only. Okay. Now leading question, as I said, already it is discussed. So your this court procedure, it is finished now.